what I was going to show you is just these last few. So that these are like old family photos, but this was the big. This is
How'd you put them on there? Did you just like
I scanned it, but these were actually postcards. But this is at Plymouth Ground, but this monument here is right. That was our house.
in Las Vegas?
Yeah. It has the deal with the symbols when they're going to Scorpion. Look, that's a shiny.
So is this house still in Vegas?
Yeah, well, it might be that. That was great. There's a little there.
That is totally yeah. That's weird.
Isn't that This is one of the ones that they have their hat on.
Watchers.
Who we were trying to, I was doing my search. I got this subscription to newspapers.com, so I can search newspapers all the way down to the.
The tissues are all the way over there. There's no buildings.
Roy's dad.
Right?
Because it's on, it's kind of outside Vegas. People have been disputed big money. Shock. Really? It was either 8 or 12 or 14. And came back and found this mule on a train. That was, it's this big a blur. And it's just like these big blurs. Shot and killed him. Shot and killed him. So he was brought into the country.
Those Michael and Garrity books about the history of Mexico. The first one was called Bad Country or something like that. It's a trilogy. He hasn't written the third one. Look up Michael McGarry. He's written a lot of
Dan is
he's written master plans. This is historical fiction, and it's all about that valley down south of Albuquerque.
Oh, right.
But anyway, it's good. They're really good. Because they go all through that.
Well, I was reading one time, this was when I was a kid, and I was
The Jornado down in there. Oh, that's nice. Then the Oregon Mountains.
Yeah.
Down in there.
Yeah. Oh, yeah. By Magdalena. By Magdalena.
It's very good. Yeah.
Well, there was, I was reading a little bit more book one time, and then the whole half of the book was in one part of it, which was, it was the town origins of the kid. I used to go in one part of it, and it was where all the soldiers would go to different bars from Fort Hughes, because Fort Hughes was right before the waters, and it was down in the canyon, and that's where our house was. And so we'd ride horseback when I was 3 or 4, and we'd go through the garden, and it had a Catholic church. My dad went down there. He had a key, the Catholic church kind of opened. We'd get in, and they're having the Virgin still, now it's all fallen down. And now it's just like there's national historic monument. But it was the end that it was the gunfights and all that kind of stuff. And then
The second one's called Bad Country. I've read the first two and they're very good.
My problem is
Talk about it. He's going down to 100th anniversary. Oh, fine.
And they're having this big.
His mom's going to be the VIP wagon.
Yeah, and we got invited to the dinner the night before the thing started, and all this kind of stuff.
How was your mom?
She's good. She's considering. Yeah, she's still kind of getting around.
What's Emma doing next year? And it's MC. Last name. Garrity.
Oh, that's
Yeah.
I'll tell Dan to stand, so that's his I don't know if she was, she's kind of.
I said Emma's here.
No.
Oh, yeah, she got promoted to graduation. I don't know if it was that. They're doing. Are you sure? No, they left my place. And they said,
Can't relive those moments.
I know. But Emma just, didn't let her bother her. She just had a lot of
Oh,
yeah, and see, and my
yeah.
Both daughters graduated at the same time. One took 2 years longer, just so she went from years in school. So Katie's got a job. But and she said, when they said, when she started this time, she goes, sorry, my dad bought me and my sister a trip to her for 2 months. So they moved here for 2 months and traveled around in your rail pass and stayed in the hospitals and stuff like that. And so she said, I can't start until the end of May. And so she and she's living there too. And I just talked to Joe the other day and she says, oh, I told you, she's great. And I was like, but she works. She works. Oh, she works 2 doubles this weekend. She works.
Take good care of her.
Right. And she just goes. And she's
Got chickens. That's all you have is chickens.
But they wouldn't let her start serving.
No, I can't. But we have the orchards and all of
And so
that.
she just,
How's that coming along?
November, and then the guy comes in.
Yeah, it's all doing well.
You getting all this moisture over there too?
Yeah. It's hampering my weeding, but I'm not complaining.
Sat down, she
I'm loving this. Yeah, loving every single thing now.
but she said, I don't have to like this once in a while.
Oh, yeah.
I don't want to serve
But
it.
we had pretty wet, you know, we went
That main manager,
this spring, the ground was doing well. So we got some
John, you're going to drown part of that ground. So now and she's just, she put that on me and I'm just doing the whole thing.
We had a really hard work for her.
Say that?
Okay, well, this is
Oh, really?
and Ella used to do that.
Most of them really good actors.
She was working at the,
Oh, that's good.
like, Musical Express. There on.
Oh, right.
And she was there.
I've got some
And it was,
holes
they served herself, but
that are really nice
and stuff, and so she did
They
that,
take
she
everything.
told me this would have.
Elected, the court is once again in session. The matter before the court at this time is DB Carbon County cause number DB 1514, Martinell et al. Plaintiffs versus Board of County Commissioners, defendants. Could I have counsel give their appearances for the record, please?
Good afternoon, Your Honor. Raymond Kuntz for the individually named neighbor defendants. That's everyone in the defendant's portion of the caption, other than the county commissioners themselves.
Alex Nixon, Carbon County Attorney, on behalf of the Board of Carbon County Commissioners, acting by and through John Grewell, John Prinke, and Doug Tucker.
Good afternoon, Your Honor. Catherine O'Brien, for the plaintiffs.
Mr. Bryant. All right, we have, I believe, motions to dismiss that's been filed by case that we're considering today. Is that correct, gentlemen?
Yes, Your Honor.
Well, you may proceed when you're ready.
Thank you, Your Honor. Certainly, Your Honor, this matter has been briefed extensively, so I'll try to be as brief as possible, and hopefully my voice
No,
will
I would concur with that.
you may be in luck because my voice may not have a whole lot of life left in it. But at any rate, I guess as a way of introduction, I would start by, for the purpose of this hearing, I'll distinguish between the terms petitioners and plaintiffs. The petitioners were, in fact, a group of people that comprised about 60% of the folks within the proposed district who came to the county commissioners with a proposed zoning district. What we have now are the plaintiffs, which are a small subset of the petitioners. What we have is 7 individuals that represent represent exactly 4 properties in the zone. Those 4 properties comprise about 5% of the zone, the proposed zone district. At this point in time, what we have is these remaining 5% that look to proceed by means of this suit to institute some sort of zoning on the balance of the 95% of the district. So I do want to make that distinction. I don't think there's any grounds for the court to impute the support now for all of the petitioners with the small subset of the plaintiffs as we move forward. I also will be referring to the defendants represented by Mr. Coons as the neighbors, as he has so named them in his briefing. These individuals, I believe 11 altogether, own about 60% of the land within the district and have been pulled into this through the commission will respectfully suggest a somewhat suspect reading of State versus Williams. I think the first thing I would like to do, and if you don't mind, Judge, since we do have some people watching here, I do have some visual aids here. This is Section 76.2.101. This is the statute that we're going to be dealing with here primarily today. It does establish the authority for the commission to make determinations regarding Part 1 zoning. It also establishes, well, hopefully, I was hoping it would come in a little bit better, maybe be focused a little bit, I apologize. It establishes 2 conditions precedent before a county can actually, County Board of Commissioners can make a determination. 1, there has to be a finding of public interest, and 2, there has to be a valid petition. Never works when you need it.
Well, Mr. Coons, if you could move it back forward.
Oh, Your Honor, it's
I'm just glad to know it's not me.
Not as good as it's gonna get it. Right. All right. Well, maybe we can just go ahead and give up on that.
So let me be clear if I can, because while I have represented counties in the past, it's been a while. So you've got, basically under Montana law, you've got 2 ways to initiate some zoning within the county. The first is the Part 1 zoning, which is a citizen-initiated zoning petition.
Correct, Judge.
And then there count 2 county zoning, that would be initiated by the Board of County Commissioners. And there's some separate procedures involved. Is that correct?
Very much so, Judge. Like I said, you do have these conditions of proceedings. There does have to be this finding, and there does have to be a petition, which is valid. It does set out a few conditions regarding a valid petition.
Well, that brings us readily to one of the larger issues, I guess, when we discuss a valid petition, and that is here, as I understand it, the petition may have not complied, and maybe both sides agree that it did not comply with the prior resolution adopted by the board relative to citizen-initiated petitions. So there's a waiver issue in that regard, but let me just posit this to you, and I'd like to get your responses as well as Mrs. O'Brien's when it's her opportunity. But why is it either the commissioners or the petitioners can waive? If this is a county resolution that requires both the county and petitioners to act in a certain way, How is it their privilege to waive this?
Well, Your Honor, it's not. There was never a waiver. What there was a discussion. There came a time when certainly the commission has to take some of the credit for, if not all the credit, for failing to recognize earlier that there was a resolution and that it had not been acknowledged or been used in the certification process by the clerk and recorder. So, as soon as that mistake was made, which was before the January 15th meeting, the commission made it clear to everybody attending the meeting that there was a resolution, had been complied with, and rather than a waiver, there had to be a decision, and that decision was what was the commission going to do. At that point in time, they knew they were going to reject the petition. So there was a determination made that because the petition is going to be rejected for independent grounds, which was based on the rescission of public interest finding that the commission was going to make, that it was at this point moved.
So is the commission's decision based on public interest here, or is the commission's decision based on the fact that a majority of the property in the district is opposing it, and so, which gets back to the petitioner's or the plaintiff's argument, I guess?
It's clearly both, Your Honor. And that can be seen in both the statements of the commission. That is, I think, acknowledged in paragraphs 48 and 52 of plaintiff's complaint. They do talk about how there was multiple grounds given by Commissioner Gruelle, and that was one, the discretion that they get through this Part 1 of 76-2101, and also an anticipation of issues involving the protest provision, which is Part 5.
Mr. Nixon, obviously one of the issues here as well is, that's been raised, is the arbitrary and capricious nature of, in this case, the rejection by the commission of this petition. And so we have a petition that arguably is not valid because it doesn't meet the requirements of the resolution. We now could conceivably sound like a waiver. Well, it's okay, it doesn't matter, we'll go ahead with it. But if you're trying to reduce the arbitrary and capricious nature of the decision, wouldn't you want a petition that complied with all of the requirements? And wouldn't that, in fact, inform your decision then? Because if it met all the requirements, it's going to give you a better platform, if you will, from which to decide as a county commission whether or not something proposed like this is, in fact, in the best interest of those involved. Do you get what I mean?
Yeah, that's exactly right. And so what you have at that point in time is the commission is well aware that there is a flawed petition. They are foreclosed from moving forward and approving it. That is that there is a fatal flaw in that it does not abide by the conditions that established in the resolution 2009-16. However, it would be unduly burdensome to go ahead and make the petitioners go back, redraw their boundaries, get surveyors, actually properly submit when there is already an independent grounds for their imminent rejection.
Which was what?
Well, there's a few different things. One, on the December 15 meeting, there was newly found information in the form of a significant amount of dissent for the petition within the district. That was previously not known to the commission. In fact, earlier in that meeting, there was a dialogue between the commission and Ms. Martinell, where she basically said that there was basically wholesale approval for the district and in support of the district. And then shortly thereafter, we hear from defendant Mr. Thusid, who informs the commission for the first time that a number of landowners owning roughly what was later determined to be 60% would in fact protest. And I think there's another important distinction there, Judge. Unfortunately, you can't see my visual aid's not working, but Mr. Kuntz, if I could have Exhibit G from the plaintiff's complaint. Just one of the. This is one of the documents received by the commission, and there's been a real effort to say that this was in fact a protest. Well, it's not for a couple of reasons. One, there's nothing more relevant than a protest provision to a commission that doesn't want to make it a district in the first place. Two, the subsection 5 has very clear language. If real property owners representing 50% of the title property ownership in the district protest the establishment of the district within 30 days of its creation, that implies a creation. We don't have a creation in the district. That is conceded by the plaintiffs. And then finally, it's important to look at the actual document that was of such concern to the plaintiffs. And what we have here, I'm reading one that was signed by Steve Thusen. And once again, this is Plaintiff's Exhibit G. What this letter reads is, by the way of this letter, it is my intent to inform you as commissioners that, should a zone be created by the commissioners, I will protest the establishment of the zone pursuant to Montana Code 762101 sub 5. I mean, approach, Judge, if it's helpful. We certainly looked at that. So, what we have really is nothing that's mandatory to the commission. What we have is something that's purely anticipatory. And so, there's certainly there's no triggering of the protest provision. This is all pending the creation of the zone. The zone is never created. The protest provision can't be triggered. To go back to your arbitrary and capricious argument, we have basically two of the causes of action, 1 and 2.
Let me stop you for just a second.
Sure.
So they received this letter, which would have come after their resolution of intent to create the district.
Yes.
And so, is there a difference then between an actual protest and information provided to the commissioners that there's substantial opposition to the creation of the district? In other words, let's just assume for a moment that the constitutional argument, and I'm not making that decision, I'm making an assumption, that the constitutional argument has some merit, that you can't delegate away this legislative authority. I think that's what the plaintiffs are relying on under the Williams case. But is it appropriate for commissioners to consider as a part of their considerations in creating a district whether or not other people within the district agree to its creation or disagree as to its creation? Do you see the difference here? I mean, is that a factor they can consider, and in considering that, they're not being arbitrary and capricious?
Well, Your Honor, you've really hit upon one of the primary flaws of the plaintiff's whole case. And that is that they are 100% dependent on the notion that any deference given to public input by these neighbors necessarily triggers the protest provision. And that puts you in a very strange, it forces you to adopt a strange theory. It in essence says that the public input of these people holds no political weight, independent of the protest provision. And certainly the commission is more than free to consider public input from anybody, including affected parties, parties that live around the zone. In fact, the commission even entertains a great deal of public input from people in neighboring counties. This is something that tends to affect the whole region. So it's really.
So you're saying it is a valid consideration, and if the commissioners make it as a part of their decision to deny the petition, then it would not be supportive of a challenge for arbitrary and capricious action. Absolutely.
And by the same way, I would say it's absolutely appropriate for a commission to consider what's still valid law. But we don't have any cases that strike down the protest provision 101 sub 5. We have a case that deals with Part 2 zoning, Williams. That was a couple of years ago. The Supreme Court declined to address the protest provision of Part 1. And so I might even say that you have a couple of problems here, one of them being separation of powers. In essence, the plaintiffs seem to be asking the commission to be making a constitutional determination of first impression. And by failing to do so, and by acknowledging what is still valid law, the plaintiffs would have you believe that that's arbitrary and capricious. In fact, case law would tend to show the exact opposite. Where boards of commission tend to get in trouble is when they do ignore statute, when they do ignore resolutions.
I would agree with that. And I do agree with what you're stating, that I think it's not the province of the county commission to decide if the statute is constitutional or not. And as long as the statute is in place, they are bound to follow.
And Judge, if I may, what we have here, we've each talked in Gateway, and it's interesting to note first, this basically involves the same court. They're about 2 years apart, if I remember correctly. It's the same court, more or less. And in Gateway, you have a desire by one party to have the protest provision in Part 2 zoning declared to be unconstitutional. However, it wasn't framed, it wasn't moved, it wasn't right for consideration by the court. And so what we have here is the plaintiffs now looking for what the Gateway Court referred to as an advisory opinion on the constitutionality of statute. And we still, as I mentioned earlier, it hasn't been triggered. There's no creation of a zone. There was never a true protest. And the first point I made, protest provision is irrelevant to a board of county commissioners that doesn't want to make a zone in the first place. So there really is no constitutional trigger. This is even though the same court that made its decision in Gateway later determined the protest provision in Part 2 zoning to be unconstitutional, they couldn't do it in the Gateway case because it just wasn't framed correctly. What we have here from the petition, there's a number of problems with the petition. You mentioned the resolution, Judge. What we have is a case that's before the court here in procedural shambles. It's not a good test case. The matter has not been framed for consideration, and it's just not appropriate for a constitutional determination. What they're looking for is what the Gateway Court called advisory opinion. To go back to the petition, I think probably one of the primary concerns that the Commission has is that the Commission lacked subject matter jurisdiction. That is, plain and simply, the proposed district was in opposition to law. For that, I do turn to 76-2109.
Before we do that, Mr. Nixon, I catch your meaning on the procedural shambles. I've often said, more in my position, I guess, as counsel for a party than as a judge, but I applied it as a judge, that if you don't get the procedure right, you can't often get to the substance. And I guess this is one of those cases where that maxim kind of comes to the forefront. And I'm not sure either, at this point anyway, either the Commission or the petitioners here are privileged to waive what the resolution required. It seems to have that waiver, as we call it, which it may not in fact be, has contributed a lot to the problems that all parties in the course now facing. That had that been followed, and then there would have been a lot more information available, and hopefully a better determination could have been made, or at least a more, I shouldn't say better, that sounds pejorative, I should say a more informed decision could have been made.
Well,
and so, what about this? I'm just interested to know from the county's standpoint, what if the court says the action taken here was simply procedurally infirm? Neither the petitioners nor the commissioners followed what was required by their own resolution. And so, all action taken at this point is null and void. You're going to have to start over. What would be the county's position on that?
certainly that's a possibility. I would also note, Judge, that that's always been available to the plaintiffs. they could have come back the next day and actually submitted a petition that complied with the resolution. There's no bar for that. We do, I think there's a couple of the footnotes in the plaintiff's response brief mentioned that they would be okay with the remand. But as a matter of, it would not seem justiciable, since that really was a remedy available to them without involving this court all along. I think I left off, I was just getting into the subject matter jurisdiction problems. That being that the regulation of agricultural land is barred by statute. Now I turn to 76-2109. This is a statute entirely without, excuse me, ambiguity. No planning district or recommendations adopted in this part shall regulate lands used for grazing, horticulture, agriculture, or the growing of timber. And there was a case cited by the plaintiffs in their brief, which is Missoula County versus American Asphalt, where the court says, an illustration of plain language expressly prohibiting regulation of particular land uses is found in section 76-2-109.
So, Mr. Nixon, is that a prohibition on the regulation of uses of land, or is that a prohibition on the regulation of lands that are delineated as such? And I think there's a difference.
Well,
if you've got land that's producing timber, for instance, and there's actual timber production, there's a prohibition against owning that land. If you've got agricultural land that's actually growing hay or raising cattle or something of that nature, there would be an actual prohibition on regulating that. If you looked at it in the one way, if you said, well, property that's capable of agriculture, or it's designated as agriculture, maybe in the clerk of or in the county treasurer's office, or however that's done, is not subject to zoning. I see that as two different things. What do you think the statute's saying?
well, it's hard to argue with the plain words of the statute. No regulation or reclamation shall regulate lands used for grazing, horticulture, agriculture, or timber. Shall not regulate. It does seem to be a prohibition against regulating land that is in the current use. There's a case cited, it's an old case, as I mentioned in my reply, it involves a 1947 RCM, but it's dual, I may be butchering the pronunciation. It's not a permanent bar to zoning, however, while used as agriculture, there is a prohibition.
Well, I've been privileged to be across a lot of lands in Carbon County, and it seems like we got a lot of agricultural lands in this county. A lot of, most of it used for grazing, hay, raising cattle, raising sheep, raising horses. So all of those lands would be outside then the ambit of this R1 zoning.
So it would seem.
That's your position.
Yes. I guess back to some of the procedural issues. We still have the petition in and of itself does seem to lack the basic legal foundation required.
Let me back up to that last question because it's important, I think. Is it your position that that was one of the considerations of the county commission at the time as well in denying this petition was that?
Lands rights issue, and I think that probably Carbon County is very indicative of most of the eastern Montana counties where zoning does not necessarily play an important land use tool. It is not really used as an important land use tool.
I get that. But under your construction of this particular statute, if the commissioners did go ahead and enact a zoning district and there were agricultural lands within that district, you don't believe that in the face of appropriate legal action taken, that the zoning district would be lawful as applied to those lands?
I guess, Your Honor, the county finds itself in a situation where we would expect to be sued no matter which way we went on that one. I would fully anticipate that we would have the opportunity to get that issue better framed when the neighbors sue the county.
Thank you. I suspect Mr. Kuntz may have a view that I need
Yes, Your Honor,
about that.
if you're more than enough, I'll let Mr. Kuntz take it from here.
Mr. Kuntz?
Afternoon, Your Honor. Your Honor, this is a 12b6 motion, brought because there is no way to arrange the facts of this case to state a valid lawsuit. And the reason that there's no way...
Even if taken as true, Mr. Kuntz, all of the facts...
Taken as true, construed in the way most favorable to the plaintiffs, and we'll even spot them a couple extra words in the quote on their brief, from Commissioner Prinky. If you take all that as true, and you construe it in their favor, there's no way to frame a lawsuit here that can be justiciable. And the reason is that from the get-go, the petition in this case is legally insufficient. Everything flows from the petition. The flow chart of the Commissioner's decision-making authority flows from the petition. The flow chart of the constitutional analysis of the 101 sub 5 protest provisions flows from the petition itself. And in fact, the analysis of harm under the Montana Constitution's environmental provision flows from the petition itself. And when the petition is itself invalid, everything else goes by the wayside. It's a threshold issue, and it's dispositive of this case.
And the petition is invalid because?
Because the signatures are not notarized. The land is not legally and fully described because there's no map outlining the borders of the district by a certified land surveyor. There's no title reports showing the ownership and authenticating the ownership of the land within the zone. And Your Honor, what Resolution 0916 requires of a zoning petition is fundamentally foundation. It serves to identify the subject matter and authenticate the petition itself. That foundation has been dispensed with and abridged here. It also provides some procedural due process, a 45 business day period for people to come in and add their names to the zone or remove their names from the zone. And the failure to follow those substantive and procedural requirements of 0916 has prejudiced the neighbors in this case.
Well, you come readily to the point, Mr. Kuntz.
I thought it might be why.
So how does, given all that you've said here, then what about this waiver argument? Number one, can the commission waive the requirements of their own resolution? The language utilized by them sounds like waiver language to me, but I don't know that that's dispositive. The question is legal, and as a policy decision, should they be allowed to waive that in making these weighty kinds of decisions?
They cannot, Your Honor. They don't have the ability to create a set of substantive and procedural rules that apply only to Part 1 zoning petitions. Resolution 0916 has no other function than to govern Part 1 zoning petitions. It doesn't apply to rural improvement districts. It doesn't apply to road districts. It doesn't apply to petitions for anything other than Part 1 zoning. Having made a series of substantive and procedural rules that apply only to Part 1 zoning petitions, the commissioners cannot then waive those rules when a Part 1 zoning petition comes along. The rules don't exist for any other purpose. These are not general administrative procedures.
So then, what is the legal consequence of failure to follow their own resolution in that regard?
All actions subsequently taken are void.
So essentially we're back to square one.
Absolutely.
And it would require then a petition that would have to follow the dictates of the resolution in order to be legitimate to review
That's exactly right, Your Honor. In order for there to be a petition upon which a zoning district is based, it's got to first meet those substantive and procedural requirements.
So in your opinion, and representing the neighbors in this case, does the court dismiss, or does the court simply remand? Of course, there's nothing to remand I suppose, if the petitioner doesn't meet the requirements of those sections.
Remand would be pointless, Your Honor. It's simply sending it back to the commissioners to deny it for failure to comply with 0916, as opposed to denying it because they didn't think it was a good idea. It's important to remember that there is no prohibition, as Mr. Nixon pointed out, on the plaintiffs or the petitioners in this case putting together a legally compliant petition and resubmitting it. They've been free to do that since the commissioners voted back in January.
And if the court dismissed at this point, are they still free to do so?
Absolutely. This district was not dissolved pursuant to the 101 sub 5 protest provisions, which carry the 1-year prohibition on repetition.
Well, it actually could not have been if you read the statute as it should be read, I suspect.
And that's our position as well, Your Honor. And if you look at the protests or the notices given by the neighbors and attached to the complainant's exhibit sheet, it's very clear that what they're saying is, look, if you create this zone, we're going to protest. But the zone was never created, so 101 sub 5 never kicks in. That's why the issue of 0916 is particularly important here, because it's dispositive of all these other somewhat complex and actually very interesting legal issues that are raised with respect to the constitutionality of citizen protest provisions, to the delegation of legislative authority, to the materiality of intermediate findings of public interest and convenience in the course of establishing a zoning district, and whether or not the Montana Constitution's clean and helpful environment provisions are in fact properly invoked in a procedural context. The court doesn't have to reach any of that because it's clear when the allegations of the complaint and the petition attached to the complaint are compared against the County Resolution 0916, the complaint fails to state a claim upon which relief may be granted.
Well, I will be very candid with you. I'll say that position appeals to the court because I hate to decide issues that are in a poor procedural posture. And I'm telling you that I think this case is in position right at this point. If we want to discuss and resolve those weighty issues, we'll do so in procedure, isn't it correct?
It is a well-established maxim of the law, Your Honor, that when a court has a threshold dispositive issue that will resolve a case, and will do so without requiring it to reach constitutional issues, it should do so. And we believe that's the case here.
I understand. Is there specific authority, though, or authority that would touch on this issue of waiver with respect to a governing body, waiving its own requirements, and specific requirements specific to a petition such as we have here?
Your Honor, the authority that can be found in this respect all concerns schemes where zoning is already in place. However, there is authority that where a county commission fails to follow procedural rules with respect to, say, granting zoning variances, that's fatal to the granting of the variance. And so, in cases where procedural rules are not followed, and this is good, solid Montana law, that the county commission is not free to waive procedural requirements and say grant variances when it doesn't follow the law in doing so. A county resolution is an official enactment. It has legal weight, and here disregarding it should be construed in the same way as disregarding the requirements of statutes for granting zoning variances.
Thank you.
Thank you, Your Honor.
All right, Ms. O'Brien. I think what we've obviously focused here is on the procedural aspects of this case. Perhaps I've bared my mind more than you would wish me to on that issue, but at least I'm trying to be candid with you, I'm uncomfortable deciding cases that have these kind of very important issues involved in them, unless we can put the case in a better procedural posture. So I'm interested in your view on that.
Certainly, Your Honor. And at the outset, I'd like to say that the problem with the defendant's arguments today is that they're not grounded in the record. They're not consistent or based on what the commissioners actually said. And while the defendants dismiss it as a figment of the plaintiff's imagination, when we look at the commissioners' own statements, it makes clear that they relied solely on the protest provision to deny the petition. And that's important in order to respond to Your Honor's primary concern about procedure. Now, if it were the case that my clients could simply go back and comply with Resolution 2009-16 and go forward with their petition, they by all means would be interested in doing that. Contrary to Mr. Kuhn's characterization, the resolution only imposes procedural requirements, and the commissioners acknowledged that they saw no reason why the plaintiffs would be incapable of satisfying those requirements. But there would be two problems with that here, Your Honor. Three, but I'll start with two. The first is that, as I will explain in more detail, the commissioners' own statements made clear that they did rely on the protest provision to deny the petition. And if we look at the protest provision, it makes clear that when commissioners deny a petition based on protest, they are completely barred from considering any citizen zoning proposal that concerns the same lands for a period of 1 year. And so if the court were to remand this case without determining the actual basis for the commissioner's decision on the theory that the plaintiffs could just try again, it simply would not work out that way. The plaintiffs would be statutorily barred from pursuing recourse in the zoning statutes for at least 1 year.
But Ms. O'Brien, the flaw that I think I see in that argument is that commissioners were privileged at that point in time to deny the petition based on a protest vote. Now I think they were certainly aware at the time that there were going to be, that these neighbors that signed this letter were going to exercise what they felt was a statutory right to protest if the commissioners adopted the petition and created a zoning district. And that had not been done. There was an intent, I guess, to do so, which then threw it into another stage of consideration for them. So two things. One, for them to have denied the petition at that point based on nothing but protest when protests weren't statutorily able to be submitted would be a flaw. And two is consideration that a number of other landowners that would be affected apparently actively oppose this. How is that not a valid consideration for the commissioners in making the decision not to proceed? So could you answer those two questions?
Certainly. To respond to your first question, Your Honor, the defendants are incorrect that the protest statute unambiguously requires the commissioners to formally establish a zone before they can consider protests. What the provision says, as Mr. Nixon quoted, first what it says is that protests may be filed within 30 days of the district's creation. But within the same breath, the statute says that the commissioners can't create the district in the first instance if they receive those protests. So taken literally, these two aspects of the provision are contradictory. And the record of the commissioners' meetings makes clear that they, in fact, and quite understandably, found this language ambiguous. If you review the recording of the commissioners' December meeting, there was extensive discussion about this very issue. The commissioners wrestled with how to resolve these conflicting aspects of the provision and what procedure they were supposed to follow. And at 1 hour and 30 minutes in the video of that December meeting, Commissioner Ruel, I hope I'm pronouncing that properly, specifically asked the county attorney and 4 other attorneys who were in the room if the statute required them to create the district before they could consider the protest. And the attorneys responded, no, they did not have to formally create the district before they could consider the protest. And this was a reasonable interpretation of the ambiguous language. In fact, in the case of Helena Sand and Gravel versus Lewis and Clark County, which was cited in our response brief, the county followed exactly the same procedure. The county there was also considering a Part 1 zoning petition, and they did just what the commissioners did in this case. They adopted a resolution of intent, they allowed a 30-day protest period, and then they took final action on the petition. And under the...
Did that ever become an issue in that case? Are you aware?
It was not an explicit issue in the case, Your Honor. The court did not address whether that was proper, but it certainly did not even pause to consider whether there was something wrong with that process. And at the end of the day, as I'd like to emphasize, this court's review has to focus on what the commissioners actually said and how they actually interpreted the statute. Here, they reasonably interpreted this ambiguous provision to allow them to follow the procedure that they chose. And the commissioners can't abandon that interpretation now and reverse course in order to evade the plaintiff's legal challenge.
Well, they couldn't unless their own decision to try to waive the resolution is, it seems to me it's contrary to sound public policy. I mean, why have resolutions, especially specific ones, that deal with specifically the issues that we now have before us, and allow commissioners to say, I mean, conceivably people, and they're going to let their buddy do it a lot simpler than they're going to let somebody from the far eastern part of the county. You see my point. I mean, that's an exaggeration perhaps, but it's subject to those kinds of interpretations. And so when the court faces that, I'm really concerned about the fact that when you enact a resolution as a governing body, that you follow it, because it not only benefits the governing body's decisions, in other words, as I previously articulated, I think it helps them look less arbitrary and capricious, frankly. They have more information from which to make their decisions. But secondly, it puts everybody on an equal footing that may approach the commission on such an issue. So why should the court allow them to just, for whatever reason, waive the requirements of that resolution?
Well, I understand Your Honor's concern, and unfortunately, as Mr. Kuntz mentioned, there is not Montana authority that is really on point and helpful in this case. And so I believe it's at page 20 of our brief, we've cited some federal authority that stands for the principle that county bodies, government bodies, as well as administrative agencies do have the inherent authority to waive the requirements of their own rules when they find that it's reasonable to do so and no one will be prejudiced. And that's exactly what happened here. At the start of that January meeting, the commissioners acknowledged that everyone had innocently overlooked this. And they had to decide what to do next. And what they decided was, we don't see any reason why the petitioners couldn't comply. And we also realized that these are just procedural requirements, and really both the petitioners and the protesters benefited from the more relaxed procedural standards. We don't think the outcome would be any different, and we think it would be unreasonable after all of the process that had occurred to require everyone to go back and just fix their paperwork in order to go forward. And so the commissioners explicitly said no one would be held to the resolution. And that constitutes a waiver, Your Honor. And one other thing I'd like to point out, as we expressed in our response brief, most of the arguments presented to the court by the defendants are not properly before the court because they were not articulated by the commissioners. And this argument in particular illustrates the fundamental unfairness of relying on theories, reasons concocted by attorneys in order to defend the commissioner's decision. Because what happened here is during the public process, the county officials told the petitioners that they weren't going to be held to the resolution and that it was okay as a result for the commissioners to go ahead and make a final decision right then and there. There's sort of a gotcha quality to the argument that the plaintiff's complaint should be dismissed because they took the county commissioners at their word. Part of the flaw in the defendant's argument about this issue also stems from the fact that they're citing irrelevant case law in their briefs. The cases that they cite, the Dable case and, Dover Ranch versus Yellowstone County, they both deal with county officials' obligation to comply with government statutes. And nobody disputes that county officials are surely bound to follow legislative direction that's articulated in statutes. But that's fundamentally different from a resolution, which is the commissioner's own rules for the conduct of their own business. And as the federal authority that we cited helps illuminate, it's acceptable for the commissioners to do what they did, where they found that no one would be prejudiced as a result of that waiver.
But can we seriously say that no one would be prejudiced by that under these circumstances? I mean, you have neighbors here who come in and at least indicate some sort of opposition. Could they not say, look, how come the commission allowed them to go forward? I mean, is it legitimate to say that everyone in that room did not suffer prejudice because the proceedings were relaxed or the requirements were relaxed? And I'm a stickler for procedure. I always have been. But nevertheless, procedure gets these things in a correct posture so that we don't make decisions that, where not all of the information is available. And certainly there's a lot of information required by that resolution that may not have been in front of the commissioners. I do understand your argument in that regard, but I'm just saying, it seems to me like there's inherent prejudice in when a governmental entity that has specific rules for how to comply, then for whatever reason says, we're just going to relax those and not require you to go forward. Frankly, I think it's what gets us to where we are today. And so, in any event, if you have a comment, fine. If you wish to go on, that's fine.
Well, if I may respond briefly, I think it's important, Your Honor, to look both at what the resolution actually asked for and also what the petitioners did put in front of the commission. There's not a wide gulf there. The petitioners put together a very detailed petition outlining their objectives for the zone. They gathered proper signatures, which were certified by the clerk of the court. They had proposed resolutions in their initial petition that gave to give the commissioners more of an idea of what they were going for. They had articles about the environmental risks that they were hoping to address. And they did have signatures that complied with the statute that were certified by the clerk, the county clerk. So the difference, and they had a map. The difference is that their map was not prepared by a professional surveyor. It was prepared by a volunteer with expertise in GIS. And their signature pages did not conform precisely to what the resolution requires. The signatures weren't all on the same page as the petition itself, I believe, was part of the issue. So this is not a case where there are substantial procedures that deprived anyone of an opportunity to be heard or an opportunity to understand the proposal. But if I can step back for a minute, the problem here really, once again, is that the commissioners told their citizens that the resolution was not important to their decision. And aside from the issue of fairness, that statement really complicates the question of judicial review and the issues that this court should consider. The defendants disregard it, but the Supreme Court has been very clear that in reviewing county officials' decisions on zoning matters, we have to look at what the officials really said. And there's a very important purpose for that. Mr. Kuntz and Mr. Nixon have thrown out several ideas which they concede the commissioners did not actually rely on to deny the petition. Today we've discussed the resolution and we've also discussed Section 109, which deals with agriculture. But as we all agree, the commissioners didn't state that that was the reason for the decision that Your Honor is reviewing. So how are we to decide on what basis that decision should be upheld or thrown out? As the court recognized in the North 93 Neighbors case, which is discussed in our brief, it's critical that the court confine its review of the commissioner's decision to the reasons they actually gave. Because otherwise the court steps into the shoes of the commissioners and is put in the position of having to decide these issues in the first instance. I'd also like to remind the court that all that the plaintiffs are seeking here is a decision that would set the commissioner's decision aside and remand. But that, aspect of voiding the commissioner's decision is essential, because otherwise, as I said, they'll be back in the same place, barred from renewing their petition because of the protest.
The action taken thus far is void. The petitioners are allowed to proceed at their discretion with a new petition that meets the requirements of the resolution. My interest being to get everything procedurally correct in this matter, without indication from the court that there's anything that bars you from proceeding appropriately. Because I actually think that's the case here. You have said, well, we're barred by a protest. I don't think, while they were aware of a protest that was likely coming from someone, I'm not sure that I think the statute is ambiguous. I've read that statute carefully. But let's just assume, for the sake of this argument, that I find the statute's not ambiguous, that the commissioners couldn't have made the decision on the basis of a protest, because a protest was not allowed at that point, or at least not allowed to be considered as a bar. How are you prejudiced by the fact that I go ahead and do what you have requested, void the action, and say, we're back to square one, anybody's free to proceed as they deem appropriate? What is wrong with that course of action?
Well, that action unfortunately would be unsatisfactory to the plaintiffs because they would still face the bar of the unconstitutional protest petition.
Well, only if, I guess, only if it actually occurs, and only if it's unconstitutional. I mean, it might be at some point in time ruled by someone to be a proper legislative enactment. I'm not sure that's a persuasive argument for me. I don't see a bar to you proceeding, is all I'm saying. Subsequently, there may be some sort of a bar, and perhaps it's the agricultural lands bar. I don't know. But I'm not sure I need to reach all of that at this point, and I'm not sure I should proceed with a kind of a flawed procedural case when, in fact, it looks pretty strong that if you've got a large percentage of agricultural lands at issue, that the action of the commissioners may be void ab initio in any event. Those are concerns I think I can legitimately hold.
Certainly, Your Honor, and I think I could address them by turning to the issue of what the commissioner's decision was actually based on in this case. Because this is not an academic exercise, Your Honor. We're not insistent upon you reaching a constitutional issue for fun. The problem is the commissioner's statements. The commissioner's statements made plain that the protest provision was the sole basis for their decision in this case. The commissioners took final action on the petition of their January meeting. And at the beginning of that meeting, Commissioner Gruelle made a motion to rescind the resolution of intent to establish a district. And he stated in making that motion, quote, "My motion is based on subsection 5, which is the protest provision. We are not allowed to create the district." Later in the meeting, Commissioner Prinke repeated this rationale when they took their final vote to deny the petition. He said that the petition failed, quote, "under section 5 because of the protests. We couldn't move forward with this if we wanted to." This is why the plaintiffs are preoccupied with the protest provision, Your Honor, because they're stuck with the record that they have.
But here's what I would do with that, Ms. O'Brien, I think, because I know you're aware of the fact that the courts are loath to address constitutional issues when they can address these issues on any other grounds, statutory grounds or otherwise. Assuming I agreed with your position, as you just stated it, I would probably void the commissioner's decision then based on the fact that they were unable to consider those protests until the statute allowed them to do so. That is not a constitutional ruling of any sort. It's simply saying, we proceeded in a procedurally improper way, and aren't we back to square one anyway?
To clarify, Your Honor is saying that they were not authorized to consider the protest because they hadn't yet created the district?
Correct. And that's assuming that I read the statute clearly, that the protest could only come legally after creation of the district.
Well, It's our position, Your Honor, that the statute does not require formal establishment of a district before the protest can be considered. And the other issue here, if you'll
But that's subject to statutory interpretation, is it not? I mean, your position in that regard.
Of course, the proper interpretation of the provision would be subject to your interpretation. However, we come back against the bar that we have to look at the commissioner's actual reasons for their decision. And the reason that they gave was subsection 5, the protest provision. That's the rationale that we're evaluating in this proceeding.
I understand, but I'm just saying that I would evaluate it in the light of whether they could proceed correctly to consider that only after they had created the district. I mean, I think that's what it says. And I realize in the Helena cases they may not have recognized that, but frankly, you got to read that statute, read it very closely to see what is the procedurally proper way to go forward. And you know, I've been involved in cases where statutorily the court has missed it, and even the Supreme Court has missed it because nobody raised it. And we often don't consider things that nobody's contesting. But yet, perhaps the statute wasn't always followed in those cases. So I think now, though, where it has been raised, I'm obligated to read that statute, construe that statute, and say, is it procedurally proper to, in fact, consider that protest until the district has been created? And that's one of my tasks in this case, obviously. So I appreciate your insight on that. Anything else?
Well, I think given the court's inclination, I will rest on the briefing for the argument that the protest provision is unconstitutional, which I feel is addressed adequately there. But I would like to address the defendant's argument that the petition is invalid because it seeks impermissible regulation of agriculture, if I may.
Sure.
The defendants are wrong to claim that the plaintiff's petition seeks regulation of agriculture and therefore is illegal under Section 7.
Did I have counsel give their appearances for the record, please?
Good afternoon, Your Honor. Raymond Kuntz for the individually named neighbor defendants. That's everyone in the defendants' portion.
Statute certainly can include agricultural lands. It just can't lead to the imposition of regulations that target actual agricultural activity on those lands. The defendants refuse to acknowledge this distinction, but it's evident from Supreme Court precedent. In the Dual case, the court rejected the argument that agricultural lands simply cannot be included in a Part 1 zoning district. As Mr. Nixon pointed out, the court there is interpreting identical language in a precursor to the current Part 1 zoning statute. And the court looked to the plain language of that statute, which says that any area that is at least 40 acres can be included in a citizen-initiated zoning district as long as it hasn't already been zoned by an incorporated state. What the defendants seek to do is rewrite that provision to say that any area of at least 40 acres that does not include agricultural land can be zoned. But that's not what the statute says, and the court already rejected the defendant's argument in Dual. And in the Missoula County versus American Asphalt case, the court affirmed that Section 109, the provision on which the defendants rely, restricts the regulation of particular land uses. Consistent with Dual, the court did not interpret the provision to bar the inclusion of agricultural lands in a citizen-initiated zoning district.
So that gets back to my question. Are they designating uses as opposed to character of the land? Correct.
Yes, I think what the Dual case and the American Asphalt case illustrate is that the prohibition applies to the adoption of particular regulations that target particular activities like agriculture and timber production. But you could, for instance, include agricultural lands in a zoning district and regulate the number of residences that can be constructed on a parcel, or road maintenance requirements, or the provision of access for emergency services, or the conduct of industrial activities on that land. And that does not implicate the provision that the defendants rely on in Section 109. I'd also like to point out that the defendant's interpretation would lead to the absurd result that agricultural landowners like the plaintiffs would be singled out and deprived of the opportunity to pursue Part 1 zoning for their own lands. There's simply nothing in the statute that reflects legislative intent to do that. On the contrary, the zoning statutes reflect the legislature's intent to provide more protection for agricultural landowners, not less. And at the end of the day, as we pointed out in our brief, the defendant's reliance on Section 109 rings somewhat hollow in this case because they're seeking to avoid zoning regulations that would not interfere with their ability to farm, but instead would limit the ability of oil and gas companies to transform agricultural land into industrial operations.
Are we now at a position though where you're seeking decisions from the court about a perceived harm that no longer exists?
Well,
That's been alluded to in briefs, and I'm not sure I want to go too far into it, but I got a lot of things to do, and I don't need to be considering questions that are kind of esoteric, not characterized in that way, but you know what I mean. So, originally you were, I think the reason for your petition is that you're concerned about the fracking possibility of a certain oil company. It's my understanding, based on the briefing and so on, that no longer really a viable concern. What would be your position? So if it isn't, what is it are we seeking to accomplish?
Well, first, I'd just like to clarify that this issue is not directly relevant to the issue of Section 109 and the regulation of agricultural land. As Your Honor suggests, it goes to our claim under the Constitution's clean and healthful environment provisions. And as to that, I would say two things. First, the defendants narrowly focus on the abandonment of a single test well in the area, the ECA test well that's referenced in the briefs. But they don't dispute the allegations in the complaint that the area surrounding the plaintiff's land has a long history of oil and gas development, and that landowners in the proposed Silvertip district have been approached by oil companies and gas companies who are interested in exploiting those resources. At the motion to dismiss stage, those allegations have to be taken as true and construed in our favor. In addition, the Supreme Court, with respect to the clean and healthful environment provisions, has made clear that those provisions provide protection that's both anticipatory and preventive. They're not designed to protect people from immediate infliction of harm or to remedy past harm. And the defendant's theory is irreconcilable with the key case on this issue, which is Montana Environmental Information Center versus Department of Environmental Quality. Because what the defendants say is that the plaintiffs have to wait until harm has actually befallen them before they can invoke constitutional provisions that the court described as anticipatory and preventive. Further, the defendant's theory would render the protections provided by Part 1 zoning meaningless. Like the clean and healthful environment provisions themselves, zoning provides protections through forward-looking planning. As the record in this case illustrates, it's not a quick fix. It's not a process that's designed to be reactive to an imminent threat of harm. In addition, it bears pointing out that under Montana law, companies can receive drilling companies with only 10 days notice to the public of their intent to drill. It's clear at that point that the plaintiffs would have no recourse in the zoning statute.
So are you telling me that what you anticipate one of the benefits to your clients would be that there'd be some sort of regulation or prohibition of extraction of mineral resources from these lands, and that this court would have jurisdiction over those kinds of issues? I mean, don't we have a Montana Board of Oil and Gas Conservation? Wouldn't we have a requirement? I mean, when we're talking about anticipatory issues, wouldn't we have a requirement that such activities would actually cause harm to a neighbor before the neighbor would have the right to recover for such harms? I mean, I just see a plethora of issues here, frankly.
Well, if I can assuage the court's concern a little bit, the first would be to say that what the plaintiffs are seeking in this proceeding is just the opportunity to initiate a process in consultation with their county government of determining what zoning regulations are appropriate for this district. And the county has alluded to the fact that the Board of Oil and Gas Conservation or the legislature may provide preferable venues for the regulation of oil and gas development. But those arguments fall far short of demonstrating that the commissioners could not adopt any zoning regulations that would be lawful and would respond to the plaintiff's concerns. For example, the petition discusses concerns about truck traffic that's associated with oil and gas drilling going through a residential or agricultural area. They've expressed concerns about the use of industrial lighting in close proximity to homes, and they've expressed concern about determining where it's appropriate to store processed water and other things like that. There's no argument before the court that those types of regulations would be unacceptable, and it's undisputed that the county government has the authority and the obligation to pursue reasonable zoning regulations to protect the health and welfare of its citizens. And really, at this stage, any arguments about the validity of particular regulations are unripe and speculative because the commissioners never got to the stage of considering, let alone adopting, any regulations for the zoning district. They were stopped short with the protest provision.
I guess I would agree with that, but wouldn't that flow through to your clean and healthful environment arguments then? It's pretty speculative that that's even an issue at this point, when you don't even know whether the district's going to be created or what the breadth and length of the zoning regulations would be if it were created. It just seems like a stretch to me.
I understand, Your Honor, but what the plaintiffs are arguing is that by arbitrarily denying them the opportunity to pursue zoning, which is intended to provide preventive protections for their land and their health, their constitutional rights were implicated. And as we discuss in our response brief, this argument is in line with the court's holding in the MEIC case. There, the plaintiffs also were seeking procedural protections. They were challenging a statute that relieved a state agency of the obligation to analyze whether certain activities were going to harm state waters. And in fact, in that case, there was evidence that the activities weren't really going to harm the state waters. There was evidence that a few hundred feet downstream of where the pollution would occur, the levels would not be, pollutant levels in the stream would not be affected. But the court nevertheless held that because these constitutional protections are anticipatory and preventive, the plaintiffs at a minimum had standing to pursue their claim that relieving the state agency of the obligation even to consider these effects was unlawful.
Let's roll back just a bit to your request of relief. You wish for the court to remand and basically indicate to the commission that their decision was the reason for their decision, as you have described it, is invalid, correct?
That's correct.
So where does the commission go from there under that scenario?
Well, if the court grants the relief we're requesting, which to be clear is an order declaring that the protest provision is unconstitutional and setting aside the commissioner's decision in reliance on that unconstitutional protest provision, then where the commissioners would go is they could engage in a rational process where they could consider the merits of the plaintiff's petition and they could consider any opposition to the petition without the obstacle of the unconstitutional protest provision. That's what we're asking for, Your Honor.
So your position would be then that the court should just remove the protest as any kind of a valid consideration here because you think it's an unconstitutional statute?
That's correct, and because the record conclusively demonstrates in our view that that was the basis for the commissioner's decision.
But that would not prohibit them from holding another hearing and saying, you know, on the merits of this, we're not going to grant the petition.
Not at all, Your Honor. That would give the commissioners the opportunity to actually take up the issues that Mr. Nixon and Mr. Kuntz have raised about affecting agricultural lands, about complying with county resolutions, about whether the Oil and Gas Board is a better venue for some of these things, and it would allow the petitioners an opportunity to respond. That's all we're asking for, is for the court to acknowledge, in light of the record, what the commissioners actually said, which was that their decisions to rescind the resolution of intent and deny the Silvertip zoning petition were, in their words, based on and because of the protest provision.
Explain to me why this provision is unconstitutional. There's been substantial briefing on it.
Yes.
The defendants contend that there is a legislative bypass here, and that's R2 zoning. And therefore, that would render the statute at issue constitutional. It should be amended. I realize we can do this, but
I'd be happy to state it for you, Your Honor. At the outset, I'd like to say that this case really is Williams all over again. What the Williams court did was invalidate a substantially identical protest provision in the Part 2 or county-initiated zoning statute. Just like the provision at issue here, that Part 2 protest provision allowed dissenting landowners, protesting landowners, to veto a zoning proposal. And the Williams court held that this type of provision is unconstitutional for two reasons. First, the court held that the provision was an unlawful delegation of legislative power because it contained no standards or guidelines for judging the propriety of the protests. Citizens could submit protests for whatever reason they wanted or for no reason at all. The provision was also held unconstitutional as an unlawful exercise of the police power because it contained no legislative bypass that would allow the county commissioners to override the protest if they found that it was in the public interest to do so. And the Part 1 protest provision is unconstitutional for the same reasons. First of all, by its plain language, it contains no standards or guidelines for judging the propriety of a landowner's protest, and the defendants don't dispute this in their briefs. And under the court's decision in Williams, and more pointedly in Shannon versus City of Forsyth, this fact alone renders the provision unconstitutional. The court was clear in Shannon when it stated, quote, "To be upheld as a lawful delegation of legislative authority, a statute must contain standards or guidelines which can be used to judge the propriety of a neighbor's protest." There's no argument before the court that the Part 1 protest provision satisfies this standard. Clearly it does not. The provision is also unconstitutional because it doesn't contain a legislative bypass. By the plain language of the statute, the commissioners cannot create the district if adequate protests are received. Now, as Your Honor referenced, the defendants insist that the separate Part 2 zoning statute somehow functions as a legislative bypass provision for the Part 1 statute, but this is incorrect. And the plaintiffs certainly do not concede that the Williams decision somehow gave rise to a legislative bypass, as the neighbor defendants wrongly stated in their reply brief. The Williams court made clear what a legislative bypass is. The court said that a provision qualifies as a legislative bypass if it gives the county commissioners, quote, "the authority to make the final decision on a zoning proposal." The Part 1 provision fails this standard because it gives the protesting parties the final word on what happens with the citizen proposal. Now, the defendants argue that the existence of the separate Part 2 statute somehow fulfills this function. But as a matter of common sense, the commissioners' theoretical ability to advance their own zoning proposal under the separate Part 2 statute, which may or may not be the same as the defeated citizen proposal, does not satisfy the definition of a legislative bypass articulated in Williams. Under Williams, a legislative bypass must give the commissioners the power to make the final decision on the citizen proposal, not some other proposal that they might pursue in the future. The defendants also ignore that the legislature has provided two separate tracks for pursuing zoning under state law. And in the case of Ash Grove Cement Company versus Jefferson County, the Supreme Court made clear that, quote, "each statutorily authorized method for creating zoning districts and enacting zoning regulations is separate and distinct from the other." So while the defendants accuse the plaintiffs of elevating form over substance with respect to this argument, it's clear that neither the defendants nor the court are at liberty to rewrite the state zoning statutes to create a hybrid Part 1, Part 2 process that the legislature never contemplated. Further, as a practical matter, the two statutory schemes for zoning are intended to work in tandem. The two statutes, first of all, have different timelines for decision-making and judicial review. As a result, citizens will never know if the commissioners are going to pursue a comparable proposal under the Part 2 statute before their opportunity to appeal the denial of their Part 1 petition expires. In addition, the two statutes provide different opportunities for citizen involvement in developing zoning regulations. regulations. And for these reasons, the defendant's proposal to stitch together the separate Part 1 and Part 2 statutes is unworkable, it's unauthorized, and it doesn't save the Part 1 protest provision. Under Williams and Shannon, even if the defendant's argument about the legislative bypass had merit, the Part 1 provision still would be unconstitutional because it's undisputed that it has no standards or guidelines for the protests. In closing, Your Honor, I would say that the defendants go to great lengths to distract the court from the controlling facts and the controlling law in this case. But when their post hoc arguments for the commissioner's decision are stripped away, what we're left with is the commissioner's own statements. They rescinded their resolution of intent and they denied the petition in their own words because of the protests. We couldn't move forward with this if we wanted to. The defendants cannot escape the clear implications of this record or the Supreme Court's decision in Williams, and for that reason, their motion should be denied.
Let me ask you this final question. Could the commissioners have violated, I mean, that still exists in law
Of course.
with respect to citizen petitions. Commissioners weren't in a position to act against what the law indicated, right? So
Of course.
whether you're right or not about the constitutional issue, the commissioners basically, at that point in time, could rely on state laws that existed, or in fact had to act according to state laws that existed, did they not?
That's certainly correct, Your Honor. In reviewing the plaintiff's petition, the commissioners were hamstrung by the Part 1 protest provision. We absolutely agree that it's not the commissioner's province to declare state law unconstitutional. They had no way around that. And that's exactly why the plaintiffs have brought this case, because only the court is in a position to remove the obstacle of the unconstitutional protest provision. And I would submit that even if there appears to be a narrower ground on which to decide this case, the record dictates that the constitutionality of the protest provision is before you. And further, as a practical matter, if that's not resolved, we're likely to repeat this exercise, because the commissioner's hands will remain tied by the unconstitutional protest provision. Because that issue's squarely teed up, Your Honor, in this case, we would encourage you to reach it.
I think it's squarely teed up, depending on how I construe the statute issue with regard to protests. And so I'll look carefully at that. I just wish it was teed up in a more procedural way, correct?
I'm sure you're not alone in that, Your Honor.
Thank you, Mr. Brown. Appreciate it.
Your Honor, just a brief response.
Obviously, Ms. O'Brien prepared a very capable response. How do you respond?
Your Honor, let me focus narrowly on the statements with regard to the record in this case. If I may approach, I present the court with paragraphs 48 and 52 of the plaintiff's complaint. The plaintiffs have argued that the commissioner's decision is based on one ground and one ground only. That's the 12P6 motion is directed to the allegations of the complaint. The complaint clearly alleges at paragraph 48, Commissioner Gruel made a motion to rescind the commissioner's resolution of intent to create the Silverton zoning district, which he stated was based on two reasons. And at 52, the first reason, he said, was that the previous public interest finding, quote, no longer applies due to the fact that landowners holding more than 60% of the acreage in the proposed district protested its creation, quote, so it's obviously not in their public interest or convenience. In other words, there's citizen opposition. The people in the zone don't want to be in the zone. I'd also point out that Commissioner Prinky, when opening the meeting on the 15th of January, specifically listed out, and this is in the record, referred to as the January 15 meeting, what the commissioners had considered, and it's this.
This decision today is based on the extensive public input and fact finding efforts by the Commission. In addition to public input, the Commission has considered numerous educational articles presented by the parties and input from both points of view from professionals in the industry. The Commission thanks everyone who has participated in the process. As mentioned in the previous meeting, the Commission has considered input from both the original and amended petition in making this decision. Based on the extensive input received by the Commission and the newly acquired information regarding the certification of protest acres, are there any motions?
That's it, sketched out for the court in the record. The commissioners are considering the whole record in this case. To do so means that they are basing their decision on substantial evidence. So I just want to be clear that the commissioners considered everything that came before them. The commissioners are not a court of record. They are a hardworking body that has to gather every week and deal with a lot of different things, and they're not held to even the same standards of administrative punctiliousness. As an administrative agency, this is a legislative body engaged in the daily work of the county. They're considering everything that came before them. And that's in the record, and that was very clear. It's our position, Your Honor, that this case is disposed of on the threshold issue of Resolution 0916. Thank you.
Thank you, Counsel. Mr. Nixon.
Sorry, Judge.
Go ahead.
Your Honor, I guess I would just like to make a quick note. Just as the plaintiff's version of the public record defies credulity, I think similarly they also misrepresented to the court what the two cases that dealt with 109 actually did determine. I would need to look at that Dual case. It has been briefed. However, Dual involved a residential district. It was formerly agriculture. The members petitioned the county commission to become a residential area, and subsequently, the plaintiff in the case actually, excuse me, sorry. What was at issue was one of the owners of property that was formerly residential, who had joined in the petition to become a residential area, wanted to build an automobile shop. That was in violation of the ordinances that he and his residential neighbors shared. Once it was no longer in his favor to be part of this residential district, he sued, saying that because his property had previously been agricultural in nature, he was therefore exempted. That in no way gets you to where the plaintiff tried to tell you this case goes. It is an old case. It does pre-exist Part 1 and Part 2. It does concern the only way zoning was allowed in 1947. But it's just flat inaccurate. She then moves on to Missoula County versus American Asphalt. I already quoted you the holding of that court that found that 76-2109 is an illustration of plain language expressly prohibiting regulation. It's the same sort of reckless disregard for the case law as it requires the same reckless disregard of the record to come to the final conclusion. Finally, I do just like to note too that we didn't really get involved today with the statutory immunity. However, we do have the record here that shows that the county did consider a number of different reasons. They were enabled to make a legislative.
Could I ask you a question about that? Because
Please.
it was a question I did have. I mean, I can recognize immunity for the acts of the commission related to what they've done on a legislative basis. That's wholly different from the court's opportunity to review their actions.
It is. You can review the case. That's a. There is a. It's kind of a. Find yourself in uncharted waters to a certain degree, because a lot of the case law cited by the plaintiffs concerns the court's review after a zoning district has been created. where you certainly have more regulation, and where maybe you have more to review to see if the actions are consistent with what has been previously established. What's difficult is when you have more of a purely legislative decision, like the creation of the zone. Once the zone's established, there are very clear-cut rules that have to be followed. The statute's silent as to what has to be done previous to making a creation of the zone, and that's other than the fact that there are the two conditions preceding. There has to be a petition, there has to be public interest. I don't know if that answers your question, but that's.
I'd like to have you address just briefly, if you would, Ms. O'Brien's view with regard to the bypass provision. She makes a pretty persuasive argument in my mind that you can't really join these two sections for that purpose. What is your position?
It's irrelevant.
Why?
It's never triggered. The zone's not made. We have.
So you're back to the procedural process, actually.
Not procedural and both. I guess there's a number of problems in my mind, I guess. Procedurally, we can't get there. You'd asked me earlier if what the commission had relied on. And I do know that the commission did rely on the fact that they could not create a district because the 2009-16 was not complied with. Once that's decided, they were faced with the conundrum whether they send the petitioners back to the drawing board or they proceed with the inevitable, which was the denial of the district. It was the real consideration was it unduly burdensome to send the petitioners off, and they basically.
So you're suggesting that the decision was made out of expedience?
Absolutely.
Don't make them go back through overnight.
Absolutely. It's on the record, but I was part of that conversation. So I absolutely could attest to that. There was no other consideration moving forward. It would be sending them on an errand in futility. The decision was made. If you review the record, the December 15 meeting, although there was later on a resolution of intent, was very critical of the. There was, first of all, the commission read a letter from the ECA attorney, Mike Dockery, stating several legal theories against making the zone. Next, there was the consideration of a letter from ECA saying that they were no longer interested in producing the area. It was neither geologically or economically feasible. So at that point in time, it was clear there was no exigent circumstances. There was comment from the petitioner's attorneys. There was newfound information from the people in the district opposing creation. There was input from the county planner who said that it was not a meaningful district from a land use perspective. Any regulation would be better utilized in Part 2 countywide zoning. There was similarly criticism regarding adopting Part 1 instead of Part 2 zoning from the commission. Trying to remember, there was numerous, I said gerrymandering. There was also talk and concern by the commissioners in dialogue between the commission and the plaintiff, Ms. Martinell, about how it appeared to be a cobbled together, the word he used, gerrymandered district that didn't really provide protection from anything that might happen outside this roughly hewn district. So it's not that this was there was any real doubt as to where the commission stood on this. It takes some real acrobatics to come down on the position that the commission solely relied on the protest provision.
Well, that whole area raises a concern for me because obviously you have two different views of what the facts are there.
Fortunately, there's a video.
I understand that, but this is a Rule 12b6 motion, so given my proclivity towards procedure, that would kind of weigh in plaintiff's benefit because
actually, Your Honor, it's incorporated in their complaint.
Well, I understand, but what the standard of review requires is that I consider the facts as alleged in the petition or the complaint here as true. Now, you have some different facts, and I recognize all that, but if, and I think one of the big tasks that the court has here is to construe this statute and see whether protests, as alleged in the complaint, could have been considered by the commission at the time, or if that was procedurally flawed, and to proceed from there. But assuming that I adopt the plaintiff's of the statute, then isn't this decision that we make to say, well, did the commissioners act arbitrarily or not, or did the commissioners only consider the protest in making this decision? Isn't this more of a summary judgment question then, as opposed to the 6 question?
I guess where I would possibly, how I'd answer.
And if I couldn't get summary judgment because of the dispute in the facts, I guess it's going to require a little, either a trial or a hearing to determine from the court's perspective what was considered and if that was sufficient for the decision that was made.
As argued in the defendant commission's reply brief, you're required to give way to well-pled arguments. And I think that there is a schizophrenic nature in the plaintiff's complaint, and that, as I said, the court's not required to bury its head in the sand and ignore obvious inconsistencies between the record that's incorporated in the complaint. And there's inconsistencies between, as Mr. Coons mentioned, paragraphs 48 and 52, and their newfound conclusion that this was solely the sole basis of the consideration was the protest provision. It just can't be supported by their own complaint.
I'd like to ask that question of the other 2 counsel as well, if you have anything else.
Your Honor, I think probably everybody's heard pretty enough here today, and I'd simply wrap it up. Thank you.
So Brian, what's your view? I mean, obviously my decision on what this statute says is going to bear, I think, significantly on whether the commission acted appropriately. So I guess if I'm having to construe it, it's understandable they may have had some concerns about that too. But let's assume for the moment that I read it the same way you do, then isn't the next step here that I can't decide this on a 12b6 motion that would either go to summary judgment or a hearing, I guess, as to what the commissioners actually considered and whether, based on what I find they actually considered, they rendered a decision that was not arbitrary and capricious. Is that fair to say?
Well, Your Honor, we would agree with the defendants that the record in this case is essentially closed and that all of it has been put before you by the plaintiff's complaint. The videos of the relevant meetings are incorporated by reference in the complaint. And in addition, we've cited case law in our brief that makes clear that the court, it would not be proper for the court, for instance, to take testimony to elicit after the fact opinions from the commissioners about what they were relying on. Under the North 93 Neighbors case and also the Keeley construction case, the Supreme Court has made clear that we only look to what the commissioners said at the time they were making the decision. I think if
but I have 2 diametrically opposed views as to what was said, in a sense. I mean, Mr. Coons is saying, no, they certainly considered way more than just the protest. And you're saying no. I mean, that's what your complaint says, no. And the only thing I can take as true is what's in your complaint, I guess. So I'm in a bit of a conundrum here, how you want me to apply the appropriate standard.
If I may, Your Honor, I think some of the confusion results from the defendant's failure to distinguish between what was put before the commissioners and what they said their decision was based on. It's certainly the case that an abundance of evidence and public comment was put before the commission, both in favor of and opposition to the district. But in the North 93 Neighbors case, the Supreme Court made clear that we can't assume that the commissioners considered all of that and rationally...
I just saw the commissioner say that he did consider all of that.
Yes, but we can't assume that their decision was based on any particular reason
But
in
if
that
they said
body
it
of
was,
evidence.
can I assume that if they said we listened to everybody and we don't feel it's in the public interest? Can I take that at face value, Brent?
Well, there's two issues there. First, under the North 93 Neighbors case, the mere fact that the commissioners considered all the evidence doesn't equate to that evidence supplying a basis for their decision. There was a very similar circumstance in that case where the commissioners were acting on an amendment to make a zoning change. They received an abundance of public comment, and they said on the record, just like Commissioner Krinky said in the video, we've considered all of the public comment, and we're making our decision for this reason. And the county attorneys there made exactly the same argument. They said to the court, look at the record. The commissioners told you that they considered all of that evidence. But what the court said was the commissioners really left no tracks, in the court's words, about what evidence they relied on. There was a lot of evidence there. And we face the same problem here. There was a lot of evidence in front of the commissioners. But they didn't say that they were relying on the alleged gerrymandering of the district. And they didn't say that they were relying on effects on agricultural lands. And they didn't say they were relying on the resolution. All they said was, after we've considered all of this, we are denying this because of the protests. And to the extent that Commissioner Gruhl purported to articulate a separate rationale for the decision that was based on the public interest, his own statements really made clear that that was the same exact rationale as the protest provision. He said that it wasn't in the public interest because of the now certified protest acreage. And so while he might have used the words of more than one reason, the substance clearly collapses into a single reason.
Well, let me address, I guess, the white elephant in the room, so we're all very candid with one another. Let's assume then that I adopt your position, I remand to the commission, I tell them, don't consider the protest vote. They come, they hold another hearing. Then they deliver the same verdict that they delivered previously, and that is, we've considered all of this other stuff. We have considered the character of the lands, we've considered this, we've considered that, and I'm sure if they were gonna do it again, just to be candid, they will be more articulate and have more description for their decision, and they say, deny. What have we all accomplished, really?
Well,
Other than you get me to declare this statute perhaps unconstitutional if I agree with your legal position. What has been accomplished?
well, first, Your Honor, I would submit that we can't prejudge the outcome of any proceedings on remand, in fairness to all of the parties, particularly because while the commissioners recited that they considered all of these other factors, the existence of the protests really overshadowed this decision. The protests were introduced at the December meeting, which was the first public meeting on the plaintiff's petition. And clearly, the protests carried the day at the January meeting. And so I think it's fair to say that if the parties had an opportunity to make their case for the zone and against the zone, that we can't prejudge the outcome. And the other reality is the plaintiffs have a statutory right to that process. They have a right under state law to a rational process in which their county government considers their petition, not an unconstitutional process. And that in itself is worthy of a ruling from this court.
Thank you.
Thank you.
Mr. Coombs, you get the last word, I guess.
The neighbors have a right to a petition process that conforms to Resolution 0916. Thank you, Your Honor.
Thank you, counsel. Very well done. I appreciate your hard work on this. I will take everything under advisement and under decisions. Thank you.
Thank you, Your Honor.
Are you going to be able to upload that?
They're for the court's convenience, Your Honor, yes. They're all in the record already.
Could be the same. Yeah.
He's much rather be doing this artwork and not any house kind of stuff.
Is that what he's doing?
Yeah,
Working
just
on
kind
houses?
of, well, no, just our house. You know how it is when you have a new house.
Yeah.
Getting fired. We just came back from 2 weeks ago.
That's good.
So that was awesome.
Yeah, it's better to be down there in May than it is in August.
Yeah. Well,
Especially around, I mean, Santa Fe is great, but if before, I mean, Albuquerque is just hotter.
it's hot there now.
like
It just
that.
changes like that.
Did they extend that?
Yes. In fact, so every time we were in Santa
I'm just so happy I'm You know, that's a good question.
Yeah. Well, yeah, my mom. But you knew. So go on, follow the procedure and we'll show Well, someone look at, because some of those rivers, that's just one of the I mean, you have all those people. How you doing, right?
Hey, John, I made you star. Oh wait, he still has it. There you go. Where's everything?
Oh, yeah.
Well, I suppose I should go do something.
How you doing?
Well, thank you. What's that? Say, give me one
I think if I
How long ago were Tony's knee?